Welcome back. Glad to have you back. I trust you enjoyed your 5-minute break. For the remainder of our program, we're going to finish up with our discussion of the grouping rules at 3D 1.2, rules A and B. And then we are also going to move on with a discussion of assigning units for these separate harms, if you have them, discussed at 3D 1.4. Now, the thing about grouping rules at A and B, at 3D 1.2 is that these are the only two rules that require a determination of a victim. We're going to look more closely now at the actual language of the rules. First, looking at 3D 1.2 Rule A. The specific language in the guideline states that when you have counts that involve the same victim and the same act or transaction, that this is going to be a Rule A grouping. Going on and looking at Rule B, 3D 1.2b, states when you have counts that involve the same victim and two or more acts or transactions that are connected by a common criminal objective or constituting part of a common scheme or plan, that these are then going to be a Rule B grouping. Now, in some instances, it's going to be very clear to you that you've got one act versus two acts. In other instances, however, it may not be quite as clear, and we would recommend that you not split hairs and worry yourself trying to determine, do I have one act, do I have two acts? As long as you have the same victim, remember rules A and B are the only rules that require victim determination. There's no victim consideration for Rule D, and there's no victim consideration in Rule C. So as long as you've got the same victim, don't drive yourself crazy trying to determine if you've got one or two acts. Just make sure that you have one victim, and the operation for the two rules is the same. You're going to calculate an offense level for each count of conviction separately and pick the higher of the two. So if you can't make that decision, the end result is going to be the same. Let's go ahead and look at a fact pattern number 5, to illustrate a discussion of grouping pursuant to these last two rules. In this fact pattern, we have the first count of conviction, which is a violation of 21 U.S.C. 841 B1B. It's a possession with intent to distribute marijuana. The corresponding guideline for this count of conviction is going to be 2D 1.1. Our second count of conviction is a violation of 21 U.S.C. 841 D2. This is unlawful possession of a listed chemical, and the corresponding guideline for this count of conviction is going to be 2D 1.11. Now, the facts of this fact pattern would indicate that the defendant only distributed marijuana and was not involved in the manufacture of any other controlled substances. So, knowing those facts, how would these two counts group together, Krista?
Well, in keeping with consistency, we are going to first look at Rule D to see if these offenses are groupable under that subsection. If you look at 3D 1.2d, you will see that both 2D 1.1 and 2D 1.11 are listed as groupable under 3D 1.2d. But as we've been reminding you throughout the broadcast, just because offenses are listed as groupable under this subsection does not necessarily mean that they are going to be grouped under Rule D. In this case, in this fact pattern, we are specifically instructed that the defendant had nothing to do with the manufacture of any other controlled substance. He possessed with the intent to distribute marijuana and unlawfully possessed a listed chemical, which he did not use for the manufacture. So in this situation, we are not going to be grouping these offenses under Rule D. There's no mechanism really to get these two separate types of conduct aggregated into one guideline, one time. So these offenses are not of the same general type, and the conduct cannot be aggregated. So we're going to have to move on to our other grouping rules in order to determine how we're going to come up with that combined single offense level. And in this situation, if you read the commentary and the application notes at 2D 1.11, it's specifically application note 3, you will find that there is specific language instructing us to group these two types of offenses under Rule B. So again, it is very important to read all of the application notes. all of the commentary, because oftentimes there will be some specific language that will further instruct you as to the grouping rules in particular instances, and this is one of those situations. So let's move on to our next fact pattern to further illustrate our analysis of the multiple count rules. In this fact pattern, we have a defendant whose first count of conviction is found under Guideline 2D 1.1. This was a cocaine distribution conspiracy that lasted 10 years. And during this conspiracy, the defendant abused cocaine and also robbed people of drugs and money in order to support his cocaine habit. Count 2 involves the defendant being convicted of first-degree murder. What happened in this situation is that a drug deal went bad and a bystander was killed. So in this case, Rachel, how are we going to group these offenses together?
Well, I love this fact pattern. It's a great fact pattern because it's tricky and it also requires you to think out of the box, so to speak. So let's get started with our analysis by looking at our 2 counts of conviction. First of all, you want to look at Rule D. Are either one of these offenses types of offenses that can be grouped pursuant to Rule D? And as you have already known from this broadcast, 2D 1.1 is listed at Rule D. However, 2A 1.1 is not listed at Rule D. And a matter of fact, it's not listed for grouping at Rule D. It's listed as specifically excluded. All Chapter 2 Part A offenses are specifically excluded from grouping at Rule D because they represent separate and distinct harms. They're not representing one composite harm. So we're doing the calculations for our 2 counts of conviction. And we come to the first count of conviction, which is the cocaine distribution count. 2D 1.1 is the guideline for that count of conviction. Now, as you're working through the specific offense characteristics, you're going to come to a cross-reference at the end of the guideline that states that if a victim was killed during the course of the offense that would constitute murder in violation of Section 1111 of the U.S. Code, then the cross-reference is to apply, and you are to go to the murder guideline and apply that guideline. Now, 1B 1.5 is where you will find instructions for applying cross-references. And 1B 1.5 states that anytime you apply a cross-reference, you are to come entirely out of the guideline that you're working with and apply that new guideline in its entirety. Unless you're otherwise specified to do so, you are to apply that new guideline in its entirety. So once again, we have the cross-reference applying here at 2D 1.1, and we're going to cross-reference to 2A 1.1. Now, because of this cross-reference, we now have, for guideline calculation purposes, 2 counts of murder, or 2 counts that are going to be determined pursuant to the guideline at 2A 1.1. Now, we still have in the real world, so to speak, 2 counts of conviction, one being the cocaine distribution and one being the murder count. So when you go to impose the sentence, you're going to have to impose the sentence on the basis of those 2 counts. But for guideline application purposes, we're sort of working with a different game here. We've got, because of the cross-reference once again, and the fact that the victim in the murder count is the same victim, this innocent bystander that was killed during the drug distribution count, and the basis of that cross-reference, we now have 2 counts of murder. That's going to be, if you will recall, a Rule A grouping. Same victim and the same act.
That's right. Now, thus far we've been discussing the grouping rules pursuant to 3D 1.2, where we have offenses that are represented by, that comprise a single composite harm. So let's go back to the slide that we started off our broadcast with about the steps for grouping. We've gone through the grouping steps. We've discussed grouping under Rule D and why it's so important to consider that rule first, and how we talk about applying one guideline one time whenever you have multiple counts of conviction that are groupable under Rule D. We've also spent some time discussing the grouping under Rules A, B, and C, or as found in 3D 1.2, and the differences between the mechanism for grouping under Rules A, B, and C versus one guideline one time, as we do under Rule D. The second step is where we're going to focus the rest of our broadcast today, and that's for incremental increases. And here we have the assignment of units, and those assignment of units results in additional offense levels because these multiple counts have been determined to represent a separate and distinct harm and therefore warrants incremental punishment. So again, we are going to turn to our principal training advisor, Rusty Burris, in another video clip who is going to give us some information about incremental increases and the assignment of units.
But now what do we do if we have more than one harm? How do we approach that? Well, the incremental increases, assignment of units, and additional offense levels. Incremental increases, if there's more than one group, here's the process. You compare the offense level of the highest group to the offense levels of the other groups. You compare each of my harms. What's my offense level for each of my harms? I increase the offense level of the highest group, the highest harm, according to a table. Now, this is all just purely almost mathematical at this point. I've got the 5 counts of fraud that I've grouped together because they all grouped under Rule D, and the offense level for those was a 23. I had a robbery and assault of the same victim, and I grouped those 2 counts together, and they got a 24. I had a separate robbery that was a 28. Out of, 5, 6, 7, 8, out of 8 counts of conviction, going through my grouping rules, I've decided, well, 8 counts of conviction, but just really 3 harms. And here's the offense levels for the harms. Now, I want to give some increase in punishment, because there's not just 1 harm here, there are 3 harms. We want to give some more punishment for 3 harms. At 3D 1.4, you look at the offense levels, and you add units based on those. The highest offense level, whatever that number is going to get a unit. Unit doesn't mean anything. It just translates into something. 1 to 4 levels less serious picks up a unit. 5 to 8 levels less serious, half a unit. 9 or more levels less serious, no units. So let's assign units here. We have a 23, a 24, a 28. Well, the highest of those is the 28. It picks up a unit. The 24, in comparison to the 28, that is close enough in harm that it picks up a unit. The 23 and to the 28, that's 5 offense levels difference. It's remote enough that it picks up a half a unit. Again, looking at the guidelines table, it's just a table in the book. 3D 1.4, you total the units, 2.5. And at 3D 1.4, it says if you have 2.5 units, that's going to translate into 3 additional offense levels. 3 additional offense levels are going to be added to what? Well, our highest group that we were using as our most serious harm was a 28. We've added the 3 additional offense levels, and we have an offense level of 31, which is our offense level for these multiple counts of conviction.
Thank you, Rusty. Now, it's important to remember that Section 3D 1.4 sanctions for additional or significant additional criminal conduct. So when you have a count of conviction that represents an additional harm or a separate harm, you want to increase your punishment for that significant additional criminal conduct, and you want to increase it incrementally. So let's look again at the rules at 3D 1.4. If you have more than one group, what you want to do is compare the offense level for the highest group to the offense levels of the other groups. Then what you're going to do is increase that offense level of the highest group, that's always kind of your starting point, according to a guideline table that we give you at 3D 1.4. Now when it comes to assigning units, your highest offense level, the count or the group of counts for your highest offense level, is going to get 1 unit. Anything equal to that is also going to get 1 unit. And as you can see, you just go down the table depending on the levels that you have and add the corresponding number of units. Now, the Commission has decided that anything that is 9 or more levels less serious is probably less serious enough not to warrant additional punishment, and therefore you're not going to get any units for that. Once you determine your number of units, you're then going to plug them into the table. This is the mathematical equation that we referenced earlier, in order to determine how many offense levels you're going to add to the count that has your highest offense level. And as you will see, for example, if you determine that your counts are going to give you 2.5 to 3 units, then you're going to add 3 levels to the offense level for the highest count there. Now let's look at our final fact pattern. It's going to be fact number 7 for an illustration of how the assignment of units is going to work. In this particular fact pattern, we have a defendant who is convicted of 1 count of distribution of heroin. This is another violation of 21 U.S.C. 841, and the corresponding guideline is going to be 2D 1.1. Our second count is going to be a forgery count, a violation of 18 U.S.C. Section 500, and the corresponding guideline for this count is going to be 2F1.1. The facts of this case would indicate that the defendant forged postal money orders in order to support his drug habit. Krista, how would we talk about analyzing this fact pattern for grouping?
Well, again, we are going to start with Rule D. Even though we've been discussing 3D 1.4, the place to always start when you're doing your analysis for multiple counts is whether these offenses are groupable at Rule D. If you would take a look at 3D 1.2D, you will find that both of those offenses, both of those guidelines, 2D 1.1 and 2F 1.1, are listed at 3D 1.2D. However, as we've cautioned you, sometimes, even though both of those offenses are listed there as groupable under Rule D, that does not mean that you will automatically group these offenses under Rule D. There is no mechanism under the drug guideline or under the fraud guideline that is going to allow you to aggregate the conduct and apply one guideline one time. You're not going to be able to add the quantity of drugs along with the value of the postal orders that were forged and place that under one guideline and take care of the defendant's conduct in that way. So Rule D is not applicable. Let's then go and look and see if any of the other rules at 3D 1.2 would apply to this defendant. Well, looking at Rules A and B, we know that we need the same victim and one act, as in Rule A, or in Rule B, the same victim and two or more acts connected by a common criminal objective. In this situation, we do not have the same victim. The victim of the drug trafficking is society in general. The victim of the forgery of the U.S. postal money orders is the U.S. Postal Service. So we have two different victims in this situation, and therefore Rules A and B are not going to apply either. So let's take a look at Rule C now. And we know that Rule C states when one of the counts embodies the conduct that is contained as a specific offense characteristic in or other adjustment to the other of the counts, that would represent a composite harm and would be available for grouping under C. But again, we don't have that in this situation either. There is no specific offense characteristic or adjustment to either of the counts that would embody the conduct of the other count. So we know that we are not under 3D 1.2. We are not going to group these together because they represent a single composite harm. So we're going to go on to 3D 1.4. And what we've established by going to 3D 1.4 is that we have two separate harms that need to result in an incremental increase to the defendant's offense level. So after you calculate 2D 1.1 on count 1 and apply your Chapter 2 guideline, apply any applicable Chapter 3 adjustments, you're going to then apply the guideline for the forgery count, and you would apply your Chapter 2 guideline there and apply your Chapter 3 adjustments. And then, depending on which offense level comes out higher, you're going to then assign units as you compare those two offense levels. So you would assign units in this case because it does represent an incremental increase and some separate harms that need to be further punished. Now, we have spent some time talking about the assignment of units, and I think it's time now to see if we have any additional faxes that have come in. So, Lauren, do we have any faxes?
Yes, actually, we have a couple that came in. The first that we'll go to is from the Middle District of Pennsylvania. Thank you very much for sending that question. And a reminder to anybody else, we still have about 15 minutes left in the program, so there's plenty of time for you to jot down a question and run it off to the fax machine if you have it. Again, this question from the Middle District of Pennsylvania is, what about grouping multiple counts of fraud and multiple counts of money laundering? They appear to be separate and distinct harms and are treated differently by their respective guidelines. So how could they be grouped?
In keeping with the rule that we've been working with throughout this broadcast, is the first thing we want to do is look at 3D 1.2 and determine if these are offenses that are listed at 3D 1.2. And we've touched on this today, and as you will know, 2F 1.1 and 2S 1.1, or even 2S 1.2, depending on which statute of conviction you have for the money laundering, are both listed at 3D 1.2 as groupable under that rule. These are also offenses that are subject to the expanded relevant conduct that we've been talking about, and how if you apply your relevant conduct correctly, you've already done your grouping. So if you have the multiple counts of fraud, you're going to want to group all of those together. and your multiple counts of money laundering are going to group together. And the reason why the fraud stays with the fraud and the money laundering stays with the money laundering is what we touched on a little bit earlier in the show, and that's the characterization of the money. As I talked about earlier, the loss table at 2F1.1, or the definition of loss at 2F1.1, is the value of property taken, damaged, or destroyed, and the corresponding loss table reflects that. Well, the characterization of the money at the money laundering guidelines, both at 2S1.1 and 2S1.2, describes that as loss as being the value of the funds. And the loss table in those guidelines reflects the value of the funds. Now, looking at the two guidelines, you can see that there's a difference, not only in the characterization of the money, but in the loss tables themselves. So when you talk about applying one guideline one time, aggregating the amount of monies involved and plugging that into one guideline, you can see that there's no mechanism in the guidelines to do that in a situation where you have multiple counts of fraud and multiple counts of money laundering. Now, it's possible, however, that these counts can group, since they can't all group together, the fraud and the money laundering groups, under Rule D. It's possible that they could group under some of the other rules. I know that, Krista, you may want to talk about this as well. There's a lot of case law across the country on grouping of money laundering and fraud, and grouping of money laundering in general. And what you really need to do is check the case law in your district and in your circuit, because there are certain ways that they explain across the country how to group fraud and money laundering counts.
And for our purposes, I believe that when you have a fraud count and a money laundering count, or a group of fraud counts and a group of money laundering counts, usually there is going to be a specific offense characteristic in the money laundering count that would be applied that would embody the conduct of that fraud count. Sometimes that will happen specifically under 2S1.2. It's not really going to happen under 2S1.1. Now, the Commission, I believe, would say that money laundering is so closely intertwined with the underlying offense. Money laundering is the way to keep the other unlawful activity going, the way to keep the fraud going, the way to avoid detection or responsibility for the fraud. And I think in most cases we would say that these offenses would be grouped under 3D 1.2, either under Rule C or under Rule B, because they are just so closely intertwined and just function to feed off of each other almost, that they would involve technically the same victim and two or more acts or transactions. So we would advise that they are groupable under Rules B or C, but we do realize that there is a lot of case law out there in various circuits across the country, and in fact there is a circuit conflict. So you want to be sure and check your case law and make sure that your circuit, you're following the way that your circuit has advised you to do. So just be careful about your grouping decisions when they are, they're going to be couched by the case law that your circuit has decided upon.
That's right. Lauren, do we have more questions?
Yes, we do. Also along the fraud lines, I guess, here's one that says, can tax evasion be grouped, I guess guideline 2, section 2T 1.1, be grouped with fraud section 2F 1.1 pursuant to 3D 1.2D?
Not to get repetitive, but we are going to start again by looking at Rule D. And we know that offenses that are under 2F 1.1 are groupable under Rule D. And we also know that 2T 1.1 is included as being groupable under Rule D. However, this is another one of those situations, as Rachel explained, where you're not going to group these offenses under Rule D because there's no way to aggregate the conduct, the quantity of money involved under one guideline one time. So you're going to calculate your fraud guideline by itself, apply your Chapter 2, any applicable Chapter 3 adjustments. You're then going to go to 2T 1.1, apply that guideline according to the provisions of relevant conduct, and also then apply Chapter 3 adjustments for that tax evasion count. Then there is a specific offense characteristic in 2T 1.1 that would embody the conduct, let's say, of this fraud count. And what that specific offense characteristic says is that if during the tax evasion any of the proceeds were from unlawful criminal conduct, which in this case would be the fraud, you are going to increase by a certain amount of levels. And that specific offense characteristic under 2T 1.1 would embody the conduct of the fraud count. So this would be a Rule C grouping. Again, even though both of those offenses are listed as groupable under Rule D, you still would not group under Rule D because there's no way to aggregate that conduct. So you would group these offenses under Rule C. Do we have any other questions, Lauren?
Oh, sure, of course we do. We have, this one says, the defendant was convicted of drug distribution, Section 21 USC Section 841, felon in possession of a firearm, 18 USC Section 922G, and use of a weapon during a drug trafficking offense, Title 18 USC Section 924C. The firearms forming the basis of the weapons counts were both used in the drug distribution scheme, so how could these counts be grouped?
The first thing I want to point out before we get started on our analysis of this particular fact pattern is we have a violation here of 18 U.S.C. 924C. And if you will remember from the beginning of the broadcast, this is one of those offenses that is specifically excluded from the grouping rules entirely. The statute requires a specified term of imprisonment for this offense and also requires that that term of imprisonment is to run consecutively to any other term of imprisonment imposed. So the first thing we decide is that the 924C violation and the corresponding guideline 2K2.4, we're going to put it off to the side because it does not apply when we're talking about the grouping rules. The second thing we want to do, not to get repetitive again, is to look at Rule D and see, are these offenses listed as groupable at Rule D? And you will find that 2D 1.1 and 2K 2.1, the corresponding guidelines for the other counts of conviction, the drug distribution and the felon in possession, are both listed at Rule D. However, there are some tricky things that happen here. Krista, do you want to walk us through the application of these two counts?
Sure. Well, because of 2K2.4, because of that 924C count, there is special instruction contained in 2K2.4 which will tell you not to apply any specific offense characteristic relating to the use of a firearm. So when you're applying 2D 1.1 for your drug behavior, you're not going to give that increase for use of a gun during that offense. And when you're applying 2K 2.1 for the felon in possession, you would not apply specific offense characteristic B5, which states that if you use or possess any firearm or ammunition in connection with another felony offense, you would increase by 4 levels, and it also provides a floor in that specific offense characteristic. But because of the 924C count, you are not going to be able to give points under either of those specific offense characteristics. Now, even though, as Rachel mentioned, both of these are groupable under Rule D, there's no mechanism to combine drugs and guns into one table and calculate it all under one guideline. So we are dealing with either a Rule A, B, or C grouping. We would apply the guidelines to the first count of 2D 1.1, apply all the base offense level, the specific offense characteristics, except for the use of that gun, and any Chapter 3 adjustments. Then we're going to apply the Chapter 2 guideline for the felon in possession count, 2K 2.1, and you'll apply the base offense level and any specific offense characteristics except for that B5 specific offense characteristic for the use or possession of the firearm in connection with another felony offense. Now here's where it gets a little tricky. Depending on application under 2K 2.1, we have two different options for how we're going to group these offenses together. If under 2K 2.1, when you get to the cross-reference under C1, if the underlying offense, which would be the drug trafficking offense, the offense in count 1, if that offense would result in a greater offense level than what was calculated under 2K 2.1, you are going to cross-reference out of the felon in possession guideline to the drug guideline. And in that situation, you would have, as in Rachel's earlier example, 2 counts of drug trafficking that involve the same quantity of drugs. Now, you don't want to aggregate these together, but you would group these offenses under Rule A because you have the same victim and the same act. It's the same calculation. So if your cross-reference applies under 2K 2.1 and you cross-reference out to the drugs, that would be a Rule A grouping. However, if the felon in possession count results in a greater offense level than the drug distribution count, you're not going to be able to cross-reference. But remember when I mentioned when we were talking about Rule C, when sometimes a specific offense characteristic is not applied but still would be considered to embody the conduct of that other count? Well, this is exactly that situation. If you don't cross-reference out of the felon in possession guideline to the drug guideline, because the felon in possession comes out higher, that B5 characteristic that I told you not to apply because of the 2K2.4 instruction, when you have the 924C conviction, you are going to group those under Rule C. That embodies the conduct of that other count of conviction, that drug trafficking. So in this situation, it's either a Rule A or a Rule C grouping, depending on how 2K2.1 was applied. Well, I think that's all the time that we have for questions today, but we want to remind you that if you have any questions that we did not get to today, please feel free to call us on the helpline. We're at 202-502-4545. We operate Monday through Friday from 8:30 a.m. to 5 o'clock p.m., so please give us a call with any kinds of questions that you have regarding guideline application. And also, please be sure to check out our website at www.ussc.gov, where there's plenty of educational materials and summary of case law and training exercises and lots of other information that will help you with your guideline analysis. We hope you've enjoyed our broadcast. We want to thank you for joining us, but we're going to go back to Lauren for just a couple minutes to wrap it up. Lauren?
Thanks. I guess that wraps it up for today's broadcast. We've reached the end of our program. Our next program in the Sentencing Guidelines series is scheduled to air this coming July, and its special focus will focus on criminal history next time. So be sure to watch the FJTN Bulletin for details as to when, the exact details as to when it will air in your area, also the times when it will be rebroadcast and all that other good information there. Please remember to fax in your rosters, participant rosters, and your program evaluations. We really do use your comments on your evaluations to help us plan our future FJTN programming and additional topics to be considered for programs in this Sentencing Guidelines series. What kinds of things do you think we should cover when discussing sentencing guidelines? And finally, just want to remember, if you are applying for CLE credit, be sure you fill out those, check off those boxes on the roster and fill out the evaluation form, the box on the evaluation form. We want everybody to fill out the evaluation form, but if you're applying for CLE credit, you also have that box to complete as well. So with that, for all of us here today, thank you very much for participating and enjoy the rest of your day.